Welcome back to the Explainer for Module 2. Today, we are tackling legal positivism. If you've ever stopped to wonder what actually gives the rules governing our lives their power, well, you're absolutely in the right place. Let's get right into it.
We're going to kick things off with a highly provocative question. Think about it for a second. What actually makes a law valid? Does a law have to be inherently good or morally true to be binding on us? Or is law just a manifestation of pure, concentrated human power? For the thinkers we are exploring today, the answer is unequivocally the latter. The beating heart of positivism is this core slogan, commonly known as the separation thesis. It's the idea of law as it is, not as it ought to be. Positivists demand a strict, unwavering boundary between the law itself and our own personal morality. They argue that declaring what the law is happens to be a totally different enterprise from debating what the law ought to be. We're dealing with cold, hard facts here, not feelings. To put that into perspective, contrast this with natural law. Natural law is ethereal and abstract. Think divine light, objective moral truths, philosophy rooted in nature. Legal positivism, on the other hand, is rigid. It's concrete. It's the sprawling, human-made structures of cities and parliaments. For a positivist, a law's validity depends solely on its source, like a legislature passing a bill, and has absolutely nothing to do with its moral content. Under this view, an incredibly unjust law is still technically a valid law.
All right, let's move into Act 2, Jeremy Bentham and the principle of utility. Let's step back into 18th century London. Jeremy Bentham, often seen as the father of legal positivism, wanted to completely demystify the English legal system. And he had this brilliant, slightly irreverent sense of humor. He casually dismissed the idea of abstract natural rights, the stuff championed by earlier philosophers, as nonsense upon stilts. Seriously, nonsense upon stilts. He despised vague concepts that could destabilize society. He didn't want invisible moral rights. He wanted strict, observable utility. So he argued that every single human action, and therefore every single law, is driven by two sovereign masters, pain and pleasure. This is his famous principle of utility. For Bentham, the ultimate goal of any law should be promoting the greatest happiness for the greatest number of people. He basically defined law as an assemblage of signs commanded by a sovereign specifically designed to shape human behavior around those two masters. And to actually measure this, Bentham took a wildly mathematical approach. He literally created something called the philosophic calculus. Imagine superimposing a math chart right over the human experience. He believed you could calculate the utility of a given law by weighing 7 very precise dimensions, things like intensity, duration, certainty, propinquity, fecundity, purity, and extent. It's basically an algorithm for happiness. Which brings us to Act 3, John Austin and the Command Theory of Law. Building on Bentham's work, his student John Austin came along and stripped the law down to its absolute most imposing, looming mechanism. Austin argued that a true law is simply a command issued by a sovereign and backed by the looming threat of a state-enforced sanction. That's the whole formula. Law equals command plus sovereign plus sanction. It's beautifully simple, but honestly a bit intimidating. If a rule doesn't have those three ingredients, Austin says it's simply not law properly so-called. But wait, what exactly is a sovereign in this context? In Austin's incredibly rigid framework, a sovereign is a determinate human superior. This could be a monarch or a parliament, but the key is that they receive habitual obedience from the bulk of society. And here's the kicker, they obey absolutely no one else. They are sitting right at the very top of the food chain. Because of this strict definition, Austin ruthlessly excluded some pretty major things from being considered true law, namely international law and constitutional law. Think about it. Internationally, there isn't a single global sovereign with a massive army to punish misbehaving nations. And constitutionally, well, a true sovereign can't be bound by its own rules. So Austin labeled both of these as merely positive morality. Sure, they matter socially, but in his analytical framework, they just don't make the cut as true laws. But this brings us to a really dramatic issue, one that the 20th century philosopher H.L.A. Hart pointed out. If law is really just a sovereign issuing a command backed by the threat of force, how is that conceptually any different from a gunman holding you up in a dark alley demanding your wallet? I mean, really, there has to be more to a legal system than just being bullied by the biggest guy in the room, right? And that kicks off Act 4, H.L.A. Hart and the Interlocking Gears of Law.
To fix this whole gunman problem, Hart steps in and transforms that chaotic, coercive energy into a highly sophisticated, interlocking system of gears. His core thesis is that true law isn't just brute commands. It's actually the union of two distinct types of rules. First, you have primary rules. These impose obligations, our basic duties like don't steal or don't commit violence. But a society running only on primary rules is going to be incredibly messy. So to make it work, you need secondary rules, essentially rules about rules. Hart outlines 3 specific secondary rules that act as the essential machinery needed to fix a primitive, pre-legal society. First, the rule of recognition cures uncertainty by telling us exactly how to identify what a valid law actually is. Next, the rules of change fix the problem of a static society by giving legislatures the power to formally create or repeal laws. And finally, the rules of adjudication fix sheer inefficiency by setting up courts to definitively settle disputes. When you interlock these gears together, boom, you have a functioning, modern legal system. Finally, we reach Act 5, Hans Kelsen and the Pure Theory of Law. Imagine sweeping away all the messy, real-world gears of sociology, history, and morality. Kelsen wanted to build something pristine, a clean, sterile, brilliantly lit environment for his pure theory of law. He was after an absolutely objective science of law. For him, studying law shouldn't involve endless debates about psychology or politics. The law is simply a self-contained system of oughts, or norms. Visually, this objective science takes the shape of the Stufenbau, this glowing hierarchical pyramid of norms. In Kelsen's structure, every single lower law must derive its validity strictly from a higher one. It's an unbreakable chain. A city ordinance is valid because a state law allows it. That state law is valid because the national constitution allows it. You just keep tracing the validity up the pyramid. But what happens when you finally reach the absolute peak of this pyramid? Up there sits the Grundnorm, or the basic norm. You literally can't trace it any higher. It's a presupposed foundation. It is the shared assumption by society and its officials that the Constitution itself is valid. Think of it as the invisible anchor giving the entire towering legal structure its life and validity. Now, there is a fascinating real-world twist here. Kelsen says that while validity is a purely formal concept derived from the pyramid, a legal system does require a minimum level of sociological effectiveness to survive. Meaning, if a revolution successfully overthrows the old order and people simply stop obeying the old constitution, that old legal system completely loses its validity. A brand new Grundnorm is then presupposed by the new ruling regime. So, I want to leave you with this final provocative thought. If the pristine, rigid pyramid of legal positivism ultimately relies on sociological effectiveness to survive a revolution, is the ultimate foundation of all law, when you really strip everything else away, actually just raw power? It's exactly the kind of question that keeps jurists awake at night, and I hope it leaves you with something to really chew on. Thanks for joining me on this explainer, and I'll see you next time.